in terms of the Constitution is at 143. The Supreme Court, if the Supreme Court determines that the election of the president-elect is to be invalid, a fresh election shall be held within 60 days after the determination. And Rule 22 of this court's presidential election petition rules empowers the court, after hearing a presidential election petition, to either dismiss the petition, which is what we are urging the court to do, what our clients are urging the court to do, or to declare the election of the president-elect either valid or invalid, and invalidate the declaration made by the Commission under Article 139(5), and then orders to payments. There was a reference to Section 80 of the Elections Act, and it states that the court has additional power to, quote, direct the Commission to issue a certificate of election of a president if, upon recount of the ballots cast, the winner is apparent and that the winner is not found to have committed an election offense. Our view is that this is not operative in this case. Number one, this section assumes a recount. We have no recount in this case. Number two, it's not specific to the presidential elections, as is the case with the Constitution. And number three, it says that as a precondition, as a condition precedent, whoever is getting the benefit of that relief must, of necessity, have not committed an election offense, which presupposes that there is a process for that to have been determined, which has not happened in this case. In any event, it is the contention of the petitioners that indeed the petitioners or their agents are guilty of presidential or of election offenses, and therefore they ought not to be entitled to that relief. But can I go back to the relief sought by the petitioners, especially in 005? They are very convoluted. There are many. They are conflicting. If you look at, and some of them are strange. For example, there is in paragraph 18 of the remedies sought in the petition number 005, you are asked to uphold the decision of the 4 commissioners in rejecting the declaration. No such decision or no such lawful decision exists. You are asked in paragraph 9 to order directing IBC to tally and verify, then declare. That has already happened. The tallying and verification has already happened. You are also asked to find that the elections were held in complete contravention of the Constitution, yet declare under section, hopefully 84, the petitioners, the president-elect and the deputy president-elect. Those two do not help the same. And then you also asked to get the election invalid, in which case the section kicks in that there will be a rerun in 60 days, yet to hold that the IBC, as currently constituted, cannot hold the election. In which case, again, you have a conflict that is not subject to be determined. So our view is that the totality of the relief sought raise a lot of problems, as mentioned by the judges on a number of occasions. In terms of the reliefs we are seeking the reliefs as listed out in the responses, all of them, and jointly. We are also seeking reliefs as far as the chairman is concerned, as far as the number of criminal actions stated or alleged in the respondents. I adopt all the affidavits, my lords and my ladies, stated by my learned senior Professor Gideon Mugai, and the presentations thereafter. Suffice it to say that what we have witnessed is at the tail end of a very long process. We in this country have gone through a lot of reforms as a result of elections. If you recall, the entire ECK was disbanded by legal fiat as a result of an election. Thereafter, we have had to completely redo our election infrastructure. We have come to the point where this court 5 years ago laid the law. Now, if you look at all those steps, we have taken radical steps that have cost treasure, that have cost lives, that has cost livelihoods, including staff members of the ECK who have either died in office or who have been fired as a result of being told you have all been disbanded. Our law has no problem, my lords. Our elections have no problem. The problem lies with our politics, and the problem lies with our political culture. That cannot be legislated. It cannot be delivered through litigation. It has to be elsewhere. Men and women who run for office in this country must accept that it is possible to win. Indeed, it is even more likely to lose, because typically an election involves more than two people, and the chances of the losers being more than the winner are very high. Until we accept that, we are going to be harming the country, we are going to be harming our institutions, we are going to be hurting independent institutions and individuals who work in those institutions. Kenyans who give a lot, ask for nothing, and get to be denigrated in the hallowed halls of this court. My lords, I will stop there. I will ask my... Thank you, my lords and my ladies.
My lady, learned members of the court, it gives me great pleasure to return back to the court 13 minutes and 20 seconds. Thank you very much.
Thank you very much for donating to us 13 minutes. We will... Yes. We would like to break now and resume exactly at 2, when we will start now the case for, should be, yes, I'm trying to be the case of William Ruto and also
2 commissioners. There are 2 commissioners.
Their case has been done.
You are done?
Yes.
Then it's Attorney General, because we are to respond to the Attorney General, pursuant to the leave you gave us.
Yes.
That we respond to the Attorney General. So it will...
2. Thank you.
Lawyers that President-elect William Samoei Ruto has lined up in the afternoon. But for the morning session has been quite incisive and has been quite informative. And Githu Muigai, the former Attorney General, has been leading that pack together with lawyers Kamau, Karori, and others. Well, we'll be looking at some of the things that have been able to transpire in the morning. And joining me now, my name is Ben Troy Njue, and I see Susan Thuku on the sign language interpretation. And before we head for the news, let's have a brief interpretation of what has just transpired. And I'm joined by my friend and the counsel we have been having since this hearing started. That is Henry Kurauka, who is a constitutional lawyer. Karibu sana, counsel.
Thank you.
Good to see you. Good afternoon.
My pleasure.
Now, in the morning session, IEBC has tried to demystify a lot of things, and they say when you've cleared the bush, you cannot hide in it. So the truth is slowly but surely picking up, and IEBC had their chance to speak the truth, because that is exactly what we want from the court today. And perhaps before we even go to what I've said, he talked about the attack on IEBC chairpersons has been in our electoral cycle each and every year, beginning with the late Zacchaeus Chesoni and Kivuitu. We also had Ahmed Isaac, and also we had Chebukati, who is also on the receiving end. Every election we have a chairman who one party doesn't want to see, and a chairman that is accused of serious crimes. They're talking about this coup. This is more or less like a coup. And this is happening in each election cycle.
Yes, it is very unfortunate for us Kenyans to have such chaos during elections. I believe one day it will be history, but we have also witnessed in older democracies like US having the same problems. You remember the Trump march to Capitol Hill? So it is not an isolated thing. The other thing I would like to say is that I'm so impressed by submission by both teams so far. I'm happy because the lawyers have been very magnanimous. There has been a good courtesy, and the Supreme Court has also been very, very supportive. What is required right now from the defense is to prove to the Honorable Court that the elections were free, fair, and transparent. It is true, as my teacher, Professor Muigai, says, we cannot have a perfect elections. However, the malpractices must not affect the final results. If there are some minor malpractices, those can be overlooked. And I think that is the point he was bringing across. Without going to the merits or demerits of the petitions, I would like to say that the court is very alert. I'm happy because the judges are able to discern and to summarize issues very, very well. And every matter depends on the facts, how the pleadings have been done, on the law, and also the merits of each particular case. We are looking at, I think, another very instrumental petitions in the Supreme Court related to elections. And I think Kenya is the first African country to nullify presidential elections. And that has triggered some benefits to other countries like Malawi and so on. So this is a good move. So in the afternoon, we expect the other parties who are amicus or friends of court, such as the Law Society, the Attorney General, because the Law Society will just rely on their submissions. We are also likely to have other parties before the Honorable William Ruto and Rigathi take the floor. The one thing that I would like to point out is that our senior colleagues should also allow the junior colleagues to shine, because this is an historical moment. Let us have younger lawyers as well.
And it's a good observation, Wakili, because looking at the BBI, it brought out a lot of young legal minds who we were expecting in this big case. And in 2017, we had a blend of both the old and the new generation. But unfortunately, in this petition, we are only seeing more or less senior counsels or lawyers who have been in the industry for a while.
Precisely. So I request our seniors to allow our junior lawyers also to have a bite. I'm happy our friend Gatia, senior counsel, has brought on board Melissa, who did very well in the very first petitions that we encountered. We have good friends like Dr. Mudhomi Diankolu and many others. They should be given a chance also to do a bite. The other issue maybe I would like to bring forward.
We're also expecting something, apologies for interjection, something we are expecting in the afternoon, the 2 p.m. You do remember that the recount is actually
we also expect the recount. Yes.
Yeah. And after that, kindly explain to us what happens next.
Now, when the report is tendered, that report will be for the use of the Supreme Court judges. Remember, there are a set of questions they put forward yesterday. The defense should also expect similar questions, because the answers to those questions will, play a great role in determining the feet of these petitions. So far, so good. I commend all the lawyers who have been submitting. They have done a good job so far.
And in the retallying, yesterday we did notice, and it was evident because the media was there, the returning officer, the registrar from the Supreme Court was there. There are some discrepancies in some of the forms saying that they were not stamped. These small minor discrepancies, can they affect the outcome of the case or the proceedings as well?
If they are so minor as they cannot affect the final results, then that will not affect the decision. However, if they are of great magnitude in such a way that they may affect the overall results, then that becomes a very serious issue for consideration. But whatever the outcome of the results will depend on the decision of the judges.
Yes, and I remember Guido talking about there are 3 governors, 4 senators, 4 MP elected in this election, and they are representing their clients in court, and asked them, you are contented that the IEBC, and you lauded IEBC for carrying out a free, fair, credible election for you to be voted in, but unfortunately now when it comes to the presidential petition, you want everything nullified.
I do not think they want everything nullified in these petitions, because of course the Honorable Supreme Court has no jurisdiction, original jurisdiction.
I'm saying about the what they are representing their client so that they may have the presidential election.
Has no jurisdiction to entertain petitions right now related to other elections. They only have original jurisdiction to deal with presidential elections. And therefore, it is dissimilar. The presidential election petitions or presidential elections are dissimilar from the other elections. Remember, Honorable Chepkati is accused in the presidential elections because of his role as a returning officer for the presidential elections. In other elections, we have other returning officers. We have haraos in every sub-county who declare results for MCAs and also MPs, women rep, Senate, and so on. Therefore, these are 2 different issues. The fact that you are an elected senator or MP or governor, that does not prevent you from challenging the presidential elections. Remember, any registered voter, any candidate, or even the attorney general have every right to petition for nullification of presidential elections.
And somebody had posted in one of the social media asking, I do remember Judge Isaac Lenaola saying that the request for more polling stations to be recounted was declined by the court. What necessitated or guided the Honorable Court in deciding the 15 polling stations?
First, the pleadings. Remember, every case is built depending on the pleadings or what parties have affirmed in their documents. To do otherwise is fishing expedition, and the court will not allow that. So those stations that were mentioned in the affidavits are the